Chair.
I call Stuart Nash.
Thank you very much, Mr. Chair. I'd also like to elaborate on a couple of things that Mr. Robinson has spoken about. As mentioned, electronic signatures. We have talked at length in Part 1 on this bill and how there's a move from requiring a written notice to the acceptability of an email or other form or electronic form of transaction. The reason for this is it does bring it into the 21st century and it is important. But there is a very important rider on that, and this is where electronic signatures come into play. Because if an electronic signature was not acceptable, then what in fact it would do is it would negate everything else in the bill in terms of an acceptability of the Commissioner of receiving a document on behalf of taxpayers. So it is an important thing. It is an important measure. I would say, though, that it does say in clause 73 that, and I quote, when the Commissioner receives a document bearing the electronic signature of a person, unless there are reasonable grounds to suppose otherwise, the document is treated as signed by the person. And I'm not too sure what reasonable grounds to suppose otherwise might be. It may be, for example, that it's so out of character or it is a piece of communication that is not part of the correspondence that is going on at that point in time. But I think it would be quite good to clarify that because, reasonable grounds, there is it's the sort of reasonable man test in law. But what does define reasonable grounds for accepting and not? And I suppose the one question I would have is what I wouldn't want to see is a taxpayer and the Commissioner in court because the taxpayer has said, well, I had reasonable grounds for not accepting the signature, and the taxpayer said, well, it actually was me. So that is just my one concern as the definition around those reasonable grounds. The other thing is under clauses 71, 83, 87 and 2001-2, what it does, this is part of the tax administration area to make it easier for taxpayers to actually get what they're obliged to, what they need. And this is amendments being made to the Tax Administration Act to allow the Commissioner of IRD to provide a special tax code directly to the Ministry of Social Development to help people receiving New Zealand superannuation or the veterans pension to meet their income tax obligations. So what it does is it reduces compliance costs, it makes it a lot easier, and it requires that a whole lot of less obligation on behalf of the superannuant or the veteran. I'd also like to talk very briefly about something that Mr. Cosgrove mentioned and something that Mr. Robinson alluded to, and this is the penalties for, or not the penalties I should say, is about disclosure of information. Now, crucial to this is the intention test. And this is where I think it's the only test we can have. And if it's proved that someone has intentionally disclosed private information, then that person under several different acts, and I think also their employment contract, it can have their employment terminated immediately. But the intention test is very hard to prove. And a classic case of this is actually under the Income Tax Act, where whether the sale of a property is subject to income tax or not is based around the intention of the owner of that property when they bought it. Whether the intent was to make a capital gain or whether the intent was to buy it for rental yield. And the interesting thing is the IRD has only ever successfully prosecuted one person for not complying with the Income Tax Act due to a misallocation of profits on there. So we have to just be sure that the intention test is applied correctly. And what I would hope and what I'm assuming is going to happen is that the IRD will actually issue a briefing note, if not hold briefings with all their staff around what this actually means. Now, I trust the IRD. I think they do a fantastic job, and I would never question the integrity of their staff in any way, shape or form. But what I would like to see, Mr. Chair, and what I would like to know is that the IRD are taking this as seriously as the Select Committee took it, and as a consequence of that, they do make it very, very clear to their staff the rules and regulations around this. Now, they know, I have a suspicion they know this anyway, but we do need to ensure that there is clarity, because the last thing we would want to do is have someone divulge information unintentionally but break the law, and then have to be dragged through some sort of employment court or employment dispute because the definition of intention is incorrect. Thank you, Mr. Chair.
Stuart Nash.
Thank you much, Mr. Chair. But on that note, we do understand that what is happening with government departments is very important. They are working closer together, and we do believe this needs to happen. Now, whether this is out of necessity, i.e. in Christchurch, when different departments had to come together in the same and co-locate, or whether it's just out of greater efficiency.
Sorry to interrupt the honourable member. The time has come for me to leave the chair for the dinner break. This debate is interrupted, and I shall resume the chair at 7:30.